Morning, Your Honors. My name is Edward Chang, and I'm here on behalf of the appellant Osagiede. We're here today because of a flawed decision by the Board of Bar Overseers, which led to an indefinite suspension of Mr. Osagiede. There were two flaws to the decision of the BBO. First, the use of propensity reasoning, and second, the consideration of national origin of Mr. Osagiede against him. And these two errors taint the entire proceedings against Mr. Osagiede, and we ask that these errors are not memorialized in decisions by the BBO and the SJC. First, a few background highlights. This matter concerns the poor bookkeeping records and practices of Attorney Osagiede, and he acknowledges that. He acknowledges mistakes with his IALTA account, and he acknowledges that he had a poor track record of keeping track of his client's funds versus his funds. That's one thing. And as a result of that poor bookkeeping, in August 2006, Bar Counsel filed a petition against Mr. Osagiede with respect to 4 clients. They were negligent misuse of client funds. And with respect to the 5th client, Sam Hartzog, it was intentional misuse, and that's important. The last one was intentional misuse. For the first 4, it was negligent misuse. There was a hearing in August 2007, and both of the available former clients on the negligence counts testified on behalf of Mr. Osagiede, and the only person testifying against Mr. Osagiede was Sam Hartzog on the intentional misuse. It's important to note that none of his clients lost a single penny. They were all paid anything and everything that was due to them.
That doesn't mean they weren't deprived of their money for a period of time.
That's correct, Your Honor. It's just as a larger point that none of them lost any money. The witnesses that testified concerning the negligence counts all testified that they were the reasons why they did not receive their funds on time.
But it was the fact that even though, were all of them after Mr. Osagiede had been told by Bar Counsel that he needed to have separate accounts and was still putting the money?
Yes, Your Honor.
The wrong account?
And with respect to the negligent misuse, that's not really at issue here. The only real issue is having to do with the intentional misuse.
But it is at issue, Mr. Chen, isn't it? Because, it's not as if there's one intentional misuse with no background. I think that's the import of Justice Botsford's question. This is intentional misuse that follows on quite specific requests of Bar Counsel.
Well, Your Honor, and that's the issue. The issue that led to improper propensity reasoning by the panel of Bar Counsel. And what it is you can't take other instances of negligence and conclude from that there was an intentional misuse, that there was a...
But Mr. Chang, I've read that the part of the hearing committee's decision on this point, and it seems to me that they say, we think this was intentional. We credit Sammy, I forget the last name, the client.
Hartzog. We
credit the client. And we do so for 3 reasons. Number 1, we found him generally credible. Number 2, Mr. Osagiede himself admitted that he didn't have the money to pay at the appropriate time. And then number 3, this is consistent. We credit him because this is consistent with a pattern. So it's not as, the way I took that, it isn't as though they are saying, we find here this was intentional because he's done this in the past. I thought they were saying, we find it intentional because we base that on the testimony of the client, and we find the client credible for these 3 reasons. So it's sort of removed, if you see my point.
Yes, Your Honor, absolutely. But the problem is if there's propensity reasoning, and the propensity reasoning is revealed by the language of the panel that says that is Mr. Osagiede's general disregard for his fiduciary duties. And they also talk about a pattern of misusing client funds. It is part and parcel of their reasoning that ended at the conclusion that they did. And an error is an error, Your Honor, whether or not it is cloaked as part of their findings or whether it is cloaked as or put as part of the credibility findings. That is, if, for example, and this is an extreme example, obviously, if the panel had said, we do not credit this person, Mr. Osagiede, because of his African origins, then even if it's under the aura of determining credibility, this court should still reverse because
But
that is
that's a
offensive.
separate issue. That goes to the national origin. This goes to the propensity, right?
Yes, Your Honor, but Judge Bosford's question was, if the error that we allege is in the context of making a credibility finding, isn't that different from just strictly using propensity evidence to find actions later in conformity therewith? And what I'm saying is that it's a difference. It doesn't make a difference, because if it's an error, it's an error.
So is your position that they should have only looked at the one instance of alleged negligent misuse without any reference whatsoever to the prior negligent misuse situation?
No, Your Honor. And there are a number of ways that this could have developed that would not have offended the rule against using propensity reasoning. For example, had that evidence, let me bring up Commonwealth v. Conacher. In that case, which there was evidence of a mother's prior negligent treatment of her children, the appeals court said that evidence was not germane to whether she had the specific intent to harm a separate child in a later incident, because one was negligence, one was specific intent. So in this situation, that's the same thing that happened here. That is, the panel and later the Board of Bar Overseers saw this acts of negligent conduct, and from there reasoned that he had, Mr. Osagiede, had a general disregard for his fiduciary duties. And that's this sort of propensity problem. Now, had the evidence been introduced and used to say, for example, in Commonwealth v. Walker, that there was a common modus operandi, that's a whole different question. And that is how it's properly used. In Commonwealth v. Walker, the defendant had used a certain drug, used a certain kind of process by which he lured women into his apartment, et cetera, and, Your Honor, penned that decision. And the issue there was this was a pattern of behavior that said, okay, in this last instance, it's not as much that the defendant did the rape or did the act involved, but it was that he had used the drugs in the same way. He had used the same kind of behavior in the same way.
Mr. Chang, let me ask you this. If, when you said the negligent misuse is not at issue, there were findings and rulings based on the negligent misuse, correct?
That's right.
Clearly, in crafting a sanction, the board can take into account other violations. As I understand your argument, you're going only to whether or not there was sufficient evidence to support an intentional misuse of funds.
That's correct, Your Honor.
Okay.
We do not contest, and that's why we did not contest the BBO and Bar Counsel's right to have a petition to bring forward the 4 counts of negligence as well as intentional misuse. That's what the law is, and that's why we did not contest it. What we're saying is that information with respect to the negligence was misused because it led to propensity reasoning, prior bad character kind of reasoning, and that's all forbidden.
Is it your position that the sanction would have been different if there had been 5 counts of negligent misuse of clients' funds?
Absolutely, Your Honor. As we understand the law, this kind of negligent misuse would have led to some sort of a term suspension, and in fact we were discussing with Bar Counsel what would have been the appropriate sanctions had there not been the intentional misuse. Intentional misuse has always been the heart of the problem here, Your Honor.
Thank you, Mr. Chang.
If I can just do a brief...
You've got 27 seconds.
I have 27 seconds. The last thing is the use of national origin, and the question is, why was Bar Counsel asking questions about what Mr. Osagiede considered to be home? Why does it matter? Why does it matter if Mr. Osagiede considered home to be Nigeria or the United States? He's an American citizen, and the implication that he was somebody else, the other, and that he could go home if that he was suspended was improper. Thank you, Your Honor.
Thank you, Mr. Chang. Mr. Marshall?
Good morning. May it please the Court. John Marshall for the Bar Council. We're asking you in this matter to affirm the order of the single justice of an indefinite suspension for the respondent's intentional misuse and other clients' fund violations as indicated in the record. Let me turn to the first issue raised by the respondent, the question of the hearing committee's reference to a pattern of prior misuse.
A pattern of negligent misuse.
They,
It just says misuse, it doesn't.
at that point in the decision, they were referring to a prior, a pattern of prior misuse or prior misuse. When they discussed that misuse in their discussion of count 1, they described it as at least negligent. And the reason they did that is because that's all that was charged in the petition. They went on to say they need not decide whether that misuse was intentional or whether there was deprivation, and they referred to their findings on count 5. So I'm not sure that there is a clear demarcation in the hearing committee's statements as between negligent and intentional.
But let's assume there was. Let's assume that's how we read it.
Yes, yes.
Would that have been improper? To say, well,
It wouldn't have been clear error. It certainly wouldn't have been. It would not have been clear error justifying the extraordinary relief requested by the respondent, which is a remand to the board for full new hearings. The hearing committee, as fact finder in this case, had the discretion under the Walker case and similar cases to rely upon, refer to a pattern of similar misconduct if they found a similarity, enough of a similarity to show that that was probative to the question before them.
Sure.
That's what they were referring to, and that's presumably what they found in making that connection.
I mean, the way I took it, as I said before,
Yes.
is that they're saying a reason that we believe Mr. Hartzog, when
Yes.
he says that the respondent said, don't cash this until April 28th and don't do that because I have my own bills to pay.
Yes.
The reason we believe that, in part, is because, as we found before, there is a pattern of misusing client funds.
Yes.
And this is consistent with that. So it just adds to a reason for credibility. Right?
Yes, I certainly agree with that, and I think that goes to the question of even assuming that there is some error here in the treatment of this, the next question is whether it's harmless error, and I certainly believe that it is. On the question of whether it's error, I would refer again back to the fact that they had the discretion to consider this. The respondent was on notice that these charges were included in the petition. This is not a question of uncharged misconduct, reference to uncharged misconduct.
Let me ask you this, Mr. Marshall. I don't mean
Yes,
to
Your
interrupt you. If we look at the testimony of Mr. Hartzog, is that his name?
Yes.
Is there sufficient in what he said that you leave aside, that if one left aside any reference, the reference that Justice Botsford made, and if it's harmless, you have to say it's perfect, that his evidence is so overwhelming that it's sufficient to support a finding of intentionality?
Yes.
And B, can we do that?
Yes.
And, okay, so one, I just have to look, in answer to the first, I just look at the record. B, can I do that?
I'm sorry, what was the reference to? You were asking me about Mr. Hartzog's testimony?
If I look at his testimony,
Yes.
there's a finding that this conduct was intentional.
Yes.
And that rested, as I take it, primarily on Mr. Hartzog's testimony.
That is not, that is, I
Okay.
disagree with that based upon the hearing committee's findings,
So it's his credibility plus...
plus a lot of other factors in the evidence, borne by the evidence, Your Honor. Let me review those if I could. As Associate Justice Botsford was indicating, the reference to the pattern was actually made in support of their decision to credit Mr. Hartzog's testimony about an inculpatory statement that the respondent made to Mr. Hartzog. I can't give you your money now because I had to use it to pay some other bills. That's definitely inculpatory on the question of misuse and on intent because it indicates an understanding that the money had in fact been
Right.
misused. In addition to that, there are other factors. In addition to the pattern that the hearing committee referred to, there was the fact that what Mr. Hartzog relayed the respondent as saying was in fact true, number one, and it was essentially the same. Mr. Hartzog's testimony was essentially the same as his statement in his grievance that had been filed with the board 6 weeks after the conversation. As the board pointed out in its memo, how did Mr. Hartzog know that? How did Mr. Hartzog know that his money had in fact been used for other expenses if the respondent had not told him that? And that was very strong direct evidence supporting Mr. Hartzog's credibility, and as Justice Botsford pointed out, that was a finding of credibility that the hearing committee had a right to make, and review of which is extremely limited. Secondly, on the question of intent, which is the ultimate question the respondent is attacking here, the hearing committee found and noted that the respondent had knowingly, deliberately deposited Mr. Hartzog's settlement check into his payroll account, not into his IOLTA account, which he also had at that time, not even into an operating account. He deposited it directly into the payroll account. And he did not tell Mr. Hartzog that he had received that money. And there was also a finding that Mr. Hartzog was the only signatory on the account. Then Mr. Hartzog's money was actually used over a relatively short period of about 4 to 6 weeks on other expenses. That testimony, independent of the reference to pattern, is strong, and that those facts are strong and direct support for the hearing committee's finding of intentionality. And that's why I would suggest that any error in that respect would be harmless. If I could move to the second issue, unless there are other questions on that. The question of whether references to the respondent's nationality were improper evidence of bias, evidence of improper bias. What was going on at the hearing when I cross-examined Mr. Osagiede was that he had testified that a suspension of his license to practice would cause him and his family severe financial hardship. And in fact, in their proposed findings, they repeated that request in an effort to avoid a suspension in the case. However, in response to questions from his own attorney, Mr. Osagiede also testified at some length about his current involvement in political action in Nigeria. He testified that he had run for office, that he had been involved supporting another candidate for a governorship, that he was a member of the ruling party, that he was waiting to hear about an appointment to the new government, and he referred to home and to moving home a couple of times in that testimony. I believe that opened up the question of whether or not his current plans of pursuing a political career in Nigeria contradicted his claim that he and his family would suffer severe financial hardship. And that is why I asked those questions.
I don't understand that. Why?
If he's already planning a separate career independent of his law practice in Massachusetts, then there would not be severe financial harm resulting from the loss of his license to practice law. And this wasn't something that he was just doing because he was afraid that his license was going to be suspended. He had a lifelong involvement with the political situation in Nigeria.
I take it your argument is he could have been running for Boston City Council. I mean,
yes.
The point is it's an alternative
Exactly.
career path
Yes.
that you are inquiring about.
That is correct. And so my position is that the questions were appropriate on issues that were raised by the respondent in his testimony, that the hearing committee's reference to that was exactly on the point that I've raised. They noted that the fact that the respondent was involved in a potential political career in Nigeria suggested that he hadn't met his burden of proof of showing that there would be financial hardship.
Was Mr. Osagiede a professor in this country or in Nigeria? Or?
I know that he was a professor in Nigeria. I'm not sure about in this country.
On the cases of severe hardship, have they tended to look at whether there's an alternative source of income?
This was a minor point in this case, Your Honor. Our
No,
position...
I'm just asking you. Your position is if somebody has to be sanctioned, they have to be sanctioned.
Exactly, right. And therefore, the question of how the extent of the hardship is really, on one level, irrelevant. We never know what a hearing committee is going to do with the evidence, however, which is why I was pursuing it. But I can't answer that question because I'm not sure that there are that many cases in which hardship has been discussed in that much detail.
We haven't said that, have we? I mean, we haven't said that this is a work of peculiar hardship and therefore the sanction is inappropriate?
No, not to my knowledge, Your Honor.
I don't think
Are there any
no.
cases in which somebody has argued this would, you know, I've got children or an ill mother or something, yeah, I'm a single parent?
Those arguments are made. All I can tell you is that I've cited in my brief the one case that I could find, I believe it's the McCarthy case, I'm not sure, in which there was a specific reference to that not being mitigating because, after all, the obligation of the bar discipline system is to protect the public and maintain the integrity of the bar and not to punish the respondent. With that, unless there are any other questions, I'll simply ask the Court to affirm the single justice order.
Thank you, Mr. Marshall.
Thank you very much.
All right.